I hereby introduce to you Mr. Michael Veazey.
So, Anthony, we've talked about the worst case scenario. I guess it doesn't turn up very often. But what are the most common mistakes, would you say, regarding private label sellers? And what's the easiest way to overcome those?
Let me think. The most common is they don't take all the steps to kind of protect their own rights before they begin. And what I mean by that is if they don't formally register their trademark in time. I mean, in the US, which is different from the UK and everywhere else, is trademark rights are based on first use, not first to file. But you never want to have to try to fight for your trademark later and have to prove that, yeah, they filed it first, but I was using it first. You don't want to be caught up in that fight, even though you can save yourself. It's just not a fight that you want to do. So I'd say number one is a lot of people wait too long to register their trademark. And then, like I said earlier, the biggest thing patent-wise is people start already offering if it's their own invention, if they're already putting it out into the public without protecting it. In terms of private label, if the invention was already out there and it hasn't been protected, technically, if it's already, no one else should be able to protect that, because if it's already in the public domain, they shouldn't be able to get protection for it. So I wouldn't say that it's a mistake there if you don't register someone else's, but I think people actually have to try to know the answer to that before they start selling the product, in terms of if there is no patent, have people already been selling this product out there. And basically, it will help if you know before you get started that there's no one that owns the right to it, so that you don't have to scramble later when you get a false complaint from somebody that says they own that patent. I guess basically you just need to know what to expect before it comes, so you know when to deal with. Because what we see a lot on Amazon is invalid complaints, competitors putting complaints through to you that just don't have a valid basis. But if you haven't done your research beforehand, you may get a complaint later and kind of have to scramble to determine the validity of it. If you've done your research beforehand, it's just doing a little bit of work in the beginning just pays dividends as you come down the line and you get future complaints, whether valid or invalid.
Okay, so let's talk about that then. Let's say you do get a complaint. So we talked about the worst case scenario. That's probably, a little bit over the top for most people, but it's good to know what it is and how to protect against it. Let's say somebody sends me a cease and desist letter for a product I've been selling for a couple of years. I did some decent research. Maybe I even got a preliminary search done by a lawyer for the patent side of things. What should my first step be? Should I just stop, or should I contact a lawyer, or what?
I mean, especially if you've done some beforehand, you did your due diligence, you believe you have a good faith right to sell this product, I would definitely have contact counsel to at least try to review and confirm and respond formally. Because with patent infringement, especially if it's a utility patent, the burden's on the person claiming it, and every claim in the patent, each patent has a list of claims. Every single one has to be hit for it to be infringement. If there's one difference that all the claims aren't satisfied, it just doesn't apply and there's no infringement. I mean, there's other defenses, but that's the most common defense. And I think that if you get a complaint, step one is I think you should have someone just give a quick analysis as to, do we have a good argument here to reply to them and say, actually, we don't believe there's infringement because here's how our product doesn't hit the claims in the patent that you're alleging we're infringing against.
Interesting. Okay. Now, let's talk about let's talk first about that scenario. Now, this is a bit of a tricky one. I'm not sure whether you'll be able to answer to this, but obviously this podcast is by a British person and to some extent geared to British people. They have a lot of American listeners. If you're selling in the US, as I do, and you have a situation where somebody approaches your company and says, well, via Amazon, and says that you're infringing on the intellectual property of some kind, say a patent, then what's the next step for me? Would I have to contact an American lawyer?
Since the sales are happening in the US and it's the Amazon US store, US law is going to apply, so you need an attorney that's qualified to interpret US law. So I'd say you should, if you're going to retain counsel, it should be one that's, you know, admitted to practice in the US.
Okay, well, so we're speaking to the right people then. So it sounds like an obvious point, but just, I mean, the law is such a closed book to most of us. I just thought I'd just double check that. Right, so let's move on to the area of protecting your own intellectual property. So you mentioned something which I think is very interesting, and it certainly was true for me at the beginning, that I didn't protect my own intellectual property early enough. So let's assume again that we're private labeling, so we don't have a patent, we don't have a utility patent. The first question is around design. Is a box design, for example, is that purely a trademark thing, or is there a patent side of it as well?
A box design, like do you mean like a product that's a box, or you mean like packaging?
I mean packaging for the product, but I mean the inner packaging, so that when you get it out of its Amazon sort of brown sort of outer packaging, you'd have the product there in the box, which is, you know, you might give as a gift or use yourself.
The packaging or appearance of like the product's packaging is called, it would still be trademark. Specifically, it's called trade dress. It's similar to what we were speaking about design patent, and that covers the appearance of the actual object or invention. Trade dress is a type of trademark in that trademarks are used to identify the source or the quality of goods. If you have specific packaging that's trade dress, like, so if what would be an example of trade dress? Like a good example would be like McDonald's colors can't often be trademarked unless they have secondary meaning. That's an example where the McDonald's red and yellow has kind of been associated with that brand. So example of trade dress would be like, you know, something in McDonald's packaging. But generally that trade dress is part of trademark law. What makes it different is it usually has to have secondary meaning. So it's one where you can't register a trade dress application until you've already been using the product. It has to acquire secondary meaning because it's not known to identify the source of the goods or the services until you're actually using it to do that. So it's a weird wrinkle there, but I guess the short answer is that the product packaging or appearance, in that way it falls under trademark law and not patent law.
But that's a very interesting point you've just made, if I understand correctly, that the packaging has to be used for some period before you can apply for a trademark on it. Is that correct?
Correct. Trade dress, you gain, like in the US, I said you gain trademark rights on first use. For trade dress, you can't register it before you use it, because it has to, the wrinkle in the law there is that actually has to develop secondary meaning before you use it. Another example would be like the Reese's orange, you know, on packaging. They couldn't just have filed it before they used it. After a certain amount of time, everyone became to identify, you know, that color scheme or that packaging as being Reese's product. Then they were able to apply, you know, if they were going to protect that as trade dress.
Okay, so let me just feedback, just make sure I've understood here. So I could, for example, just start trading as mikeswidgets.com. And if Mike's Widgets is something that nobody else has used, as soon as I use it on Amazon or anywhere else, that means I'm the first to use, so I have the rights to that intellectual property. Is that right, first of all?
Yes, that part is right, correct.
Okay, but if I've got a nice packaging design which has got my particular colors on it and a picture of my face smiling away next to some wonderful widgets, that I can't protect that until it's in use. But on the other hand, because I'm the first to use it, I guess I kind of own the intellectual property of that as well. Is that right?
Correct. Like you gain like the rights to it based on first use. The difference is the name, you know, mikeswidgets.com, that you can register just as a trademark before you use it, if you were going to try to protect the packaging with the image or any particular color schemes, you gain the rights based when you first use it, but you can't register it until you've used it and developed that secondary meaning.
Great. Well, that's really nice and clear. Thank you. That's certainly something I had no idea about that. So that's very, very clear. Now, the obvious question for me, and forgive me if I'm asking the dumb question, but that's kind of my job on this show, I think, increasingly. If I get the rights to the intellectual property by first use, then why do I need to bother to register it at all?
Because then you don't. What's great about having the USPTO registration is it's prima facie proof that you own a valid trademark eventually. So you don't have to, if you have rights based on first use and you don't have the registration, you still have the burden to go prove it. If someone shows up and starts using your mark, you kind of have to go to bat to prove and defend, that you've had prior use of it. Whereas, let's say you have the registration, you can just submit it to Amazon or any other entity. It's formal government recognized registration. It takes that burden of proof off of you, and it kind of serves as that proof instead. Which
Interesting. So if, for example, if somebody approached me, if I wanted to approach somebody else and I have my wonderful widgets and I have my blue pen, which I've got the private label rights to use, and I have my logo on it, and then I have some packaging, which is Mike's Widgets and so forth. If somebody else starts using Mike's Widgets as a trademark name, and I've registered it, then all I need to do is contact them. And then if they dispute it, I point to my USPTO trademark registration, and I say, that's it, you need to take it down, and that's done. Is it as simple as that, basically?
I mean, it's as simple as that in terms of it's easier to give them proof of it. If they wanted to oppose your registration, one, they should have done it when you do the application. There's a part where the trademark office publishes it to the public. So it says, we're going to register this application. If you have opposition to it, kind of speak up now, file formal papers. So if you have a formal registration, the burdens proof is easier in terms of showing them. And then if they had to oppose it, they'd have to go try to fight your actual registration. And let's say they just don't listen to you, they continue doing it. If you wanted to formally complain against them on Amazon or another platform online, all you have to do is give that documentation to the website. And most of the time, to protect themselves, other websites aren't going to act unless you have that registration. So like if you tried to appeal to Amazon and said, no, but I have the rights based on first use. Look, here's me using it, in 2012. Here's them starting to use it in 2014. It may work, but it's much easier to just be, look, here's the registration. It just makes your burden of proof easier to satisfy going forward in terms of trying to police your brand.
Okay, makes sense. So basically, we want to register reasonably soon. Is it an expensive process? I mean, how much is it going to cost me to register the trademark, the name Mike's Marvelous Widgets or something?
The actual filing, well, where it could get expensive is that you have to register your mark for each class of goods that you want to protect. So if you're going to sell, cell phone products or computers or services like food services, basically whatever range of goods, each class of goods or services has its own filing fee. They vary slightly, but it's approximately $250 per class. So where it varies is just how many classes of goods you think you need to register for.
Okay, but assuming that you're going to create a brand and therefore a trademark around as in a brand name, really, and a brand identity around a particular unified set of products, then if I sell pens and stationery and things like that, Mike's Marvelous Widgets would only cost me $250 then, from what you're saying, to register as a trademark.
Exactly. If you wanted to start with one class of goods, that would just be the filing fee. In terms of whether you had to go forward and usually you would have to go forward and do new applications if you wanted to add products, unless gray area kind of comes in as if, let's say you were selling cell phones and then you were selling cell phone accessories. You could kind of argue that it's in the natural zone of expansion from your initial registration. It's always better to to get the new registration, so it's protected. But generally, in terms of expanding, they kind of look to whether they're goods or services you would expect if you sold one, you'd sell the other or expand into the other eventually. So you can get more protection by use, but even if you're going to just start and register one class, it does potentially offer you broader protection if you expand to other products.
Yeah, I have to say $250 sounds quite cheap for me to protect the value in any kind of significant product. Really, if you're getting any kind of significant sales, that's going to be small. I mean, whereas $1,000 up front for a preliminary search for something that hasn't got any commercial value to you yet is a bit of a bigger thing to swallow. But as you say, it depends on your assessment of the situation, really. So we're going to have to wrap things up a bit because I know you've got to get back to the office and go and sort of do scarily clever lawyer things. I just wanted to ask a couple of questions really that about the future, really. What trends you see coming down the pipe in the next year or two regarding patents and trademarks in the US in general, if anything?
I just think generally it's gonna become more prevalent. People are gonna become more used to kind of dealing with patents and trademarks and speaking the lingo, because although third-party reselling isn't done on Amazon, it's a slow trend to, I mean, private label is the future and people are going to need to know more about it and they're going to need to be savvy in order to continue with the trend. So I just think that it'll be, much more important, and we'll see at least an increase in trademark registrations, and I'd say on both sides we're going to see more registrations and more complaints, just because as everyone's going to keep trying to private label, especially with patents, it's going to be on whether or not people have done the research, and even if they've done the research, we're going to have so many people trying to sell similar products that I think it's just the increase in claims is just going to be a natural byproduct of that.
Yeah, that makes total sense. Well, I was going to ask you what specific things you think is coming for Amazon, but I think you've answered the question, really. It's going to be more people trying to make claims and create problems. And I have to say that from my personal experience of, I haven't had claims against me, but working with a couple of clients a while ago who had some intellectual property claims against them, Amazon is very, very quick to shoot first and ask questions later, as with all things Amazon, unfortunately. So anything you can do to make that process of getting your products reinstated as quick and easy as possible, trust me, is really worth it, because I've had clients who've had their products, normally their best-selling products, because otherwise they wouldn't have been attacked by the competition. They've had their products taken down for 2 months. So I have to say that anything that speed that up is very worthwhile. Correct. Is there anything else that you would say as general advice for somebody who's just starting out regarding this intellectual properties sort of whole area, which everyone kind of gets a bit scared of? What's the simplest thing that somebody could do? What's the 1 or 2 simple things that people can do which are quick and fairly cheap and which give them the maximum protection? I think the biggest things you can do, you self-educate. You can find so many, even just the USPTO site, you can find a lot of resources to bring yourself up to par and just kind of at least build yourself a background base, because you should at least know you're going to be dealing with these issues. You should, one, have a general background of it yourself so you know what you're dealing with. And to me, even more important is when you self-educate, you can know kind of the base, but it's also okay to know kind of enough to just spot issues, to spot as, oh, this is a big issue. This is one that the other things, if I could deal with myself, this is something that I need to go contact someone and consult with. Further in that, I think in terms of the biggest thing you can do besides self-educate is, I think you can do that clearance search for your own private label brand and at least make sure that no one else has it, so that you can start to take the steps to protect it. So I think you would start with, self-educating yourself, and if you're going to try to protect something yourself specifically, it's a little bit simpler to try to look at trademark law yourself and at least identify, whether or not you should go forward and protect a particular brand name that you're looking at. Great. That sounds like nice, straightforward advice for people to get started with. So, Anthony, many, many thanks for your help today. Talking of self-educating, if you want to hear more, or if you want to read more, rather, from Anthony from this show, then it's at Anthony, F-A-N-T-H-O-N-Y, F of Freddie, at the blog. So amazingfba.com/blog. Anthony F, and we'll put notes and resources there to help you in detail. So, Anthony, it just remains for me to say a very big thank you for guiding us through the treacherous waters of intellectual property on Amazon. And thank you very much for sharing some very, very helpful and very practical tips for us.
Of course, Michael. It was a pleasure to be here.
Thank you so much for coming on.
Take care.
Cool. Let me just stop the podcast.